Your Honor.
Hey,
Patty, I don't think he's taken the bench yet. You need me to grab him?
We're ready when he is.
Okay, I'll tell him.
Good afternoon, Your Honor.
Good afternoon. Are we ready to go?
Yes, sir. We're going to start with Mr. White.
All right, good afternoon, Mr. White.
Good afternoon.
All right, this is cause number CR 19-48, State of Texas versus Trevor Paul Black. Mr. Black's hearing on motion to revoke. Go ahead, Mr. White.
Your Honor, I believe the state has agreed that we will pass this case because there hasn't really been enough time to get new information out, as one of the bases of the revocation is a new charge. And I believe that's what the state told me, if they would confirm what I'm saying.
Yes, Your Honor, there is a new charge. It's currently under review. I don't believe it's gone to grand jury yet.
And
How long do we anticipate that may take?
Let me check real quick here and see if it's been reviewed. Your Honor, it hasn't been reviewed yet. I can get with Mr. Hall and see if he can kind of put this one up on his priority list a little bit, since Mr. Black is in jail on this MTR, and that is one of the primary bases for the MTR.
Okay, I mean, both of you attorneys are aware that the court is statutorily obligated to set these hearings within 14 days and try to resolve them as soon as possible. So I just don't want him sitting in there for over 90 days waiting for a case that may or may not go to the grand jury.
Yes.
Your Honor, I will be probably speaking with the prosecution in regard to a bond in regard to this matter, because obviously we're not able to do this in 20 days.
Okay. All right, so what I'll do is I'll set Mr. Black on the contested docket on May 29th, and we'll see where we're at on that day.
And if he bonds out, it'd be in the morning?
If he bonds out, then his hearings will be in the morning. At 9 a.m.
All right, Your Honor, that's all I have today.
Thank you, Mr. White. Do we have anyone else that's ready?
Yes, Judge.
Who would you like first, Mr. Manning?
Judge, do you have the paperwork for the pleas that were signed earlier today?
Yeah, I believe so. Be specific with me. Let me tell you who I have and who I don't have.
Judge, if we want, we can start with Ms. Beggs.
Yes, I do have that one. All right, this is cause number CR 25-30, State of Texas versus Catherine Leanne Beggs. Ms. Beggs, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, so I've got a problem. When I clicked on the documents, it says this document has already been signed. Try this again. Catherine Beggs. Been some kind of weird kink that's there now. All right, Ms. Beggs, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done as your attorney?
Yes, sir.
Do you understand everything that you've read and signed today?
Yes, sir.
All right, Mr. Manning, do you believe Ms. Beggs to be competent to enter into an agreement today? And if so, have you explained to her the rights regarding your case and also the advantages and disadvantages of a deferred adjudication plea?
She is competent and have explained her rights, and she understands the tremendous advantages and disadvantages of deferred plea.
Ms. Beggs, you are charged by indictment with a third-degree felony offense of hindering apprehension or prosecution of a known felon. A third-degree felony in Texas does carry a range of punishment of not less than 2 years and not more than 10 years confinement in prison and a possible fine not to exceed $10,000. I see that the plea agreement in your case is upon you pleading guilty, the DA's office is recommending that the court not convict you of the offense, but they're asking the court to place you on 3 years of probation with a $1,500 fine plus court costs plus reimbursement fees of $520. And as a condition of your community supervision, you will be required to serve 60 days in the county jail, for which you will have received credit for the time that you served between December of 2024 up till February 11th of 2025. In addition, the DA's office is agreeing to dismiss an unfiled misdemeanor charge of possession of marijuana less than 2 ounces. Is that the agreement that you want the court to approve?
Yes, sir.
All right, Ms. Beggs, then how do you plead to hindering apprehension or prosecution of a known felon?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
All right, the stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement. The court defers a finding of guilt on this offense, places Ms. Beggs on 3 years community supervision, orders her to pay a $1,500 fine, $290 court costs, $520 in reimbursement fees. Further, the court does order her to serve 60 days confinement in the Van Zandt County Jail as a condition of her community supervision. Court will give her credit of that 60 days for time already served. And the court dismisses under section 1245 possession of marijuana case DA 2024-346. Ms. Beggs, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you step over there to be fingerprinted. After that, you'll meet with the probation officers.
Yes, sir. Thank you.
You're welcome.
Judge, next ready on Miss Sky Cooper.
Okay, you'll go ahead and have her come up while I'm signing these papers. All right, court calls cause numbers CR 24-95, CR 25-37, State of Texas versus Sky Brianne Cooper. And Ms. Cooper, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Ms. Cooper, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done as your attorney?
Yes, sir.
Do you have any questions about the paperwork that you've read signed today?
No, sir.
Mr. Manning, do you believe Ms. Cooper to be competent? And if so, have you explained to her her rights regarding this case?
Judge, she is competent. She understands her rights and is waiving those intentionally, knowingly, and voluntarily.
Ms. Cooper, you are originally charged in cause number CR 24-95 with possession of a controlled substance between 1 grams and 4 grams, a third-degree felony offense. I see today that the recommendation from the DA's office is upon your plea of guilty to a lesser included offense of possession of a controlled substance less than 1 gram, which would be a state jail felony. The DA's office is asking the court to consider the evidence to convict you of that offense under section 1244 B, in which you would receive a misdemeanor, class A misdemeanor conviction, and you would also be punishable up to 365 days in the county jail. It appears that the agreement is that you would serve 69 days in the county jail. You would receive credit for 39 days of time already served. In addition, you would be responsible for a $1,000 fine, restitution of $180, court costs of $270, and reimbursement fees of $655. And the DA's office is agreeing to dismiss a bail jumping case, which was indicted in cause number CR 25-37. Is that the plea agreement as you understand it?
Yes, sir.
All right, then, Ms. Cooper, how do you plead to the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, then the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, court will review the evidence. All right, court, having considered the evidence, finds enough evidence to convict the defendant of this offense. The court will follow the plea agreement and recommendation. Court hereby convicts Sky Brianne Cooper of possession of a controlled substance of penalty group 1, less than 1 gram. Court, following the plea agreement, convicts her under section 1244B of the Texas Penal Code as a class A misdemeanor. The court assesses punishment at 69 days confinement in the county jail. The court issues credit to Ms. Cooper for 39 days of time served. Court assesses a $1,000 fine, restitution of $180, court costs of $270, and reimbursement fees of $655. Further, the court does take into consideration and dismisses under section 1245, cause number CR 25-37, bail jumping. Ms. Cooper, are you going to be able to pay off your fines, court costs, reimbursement fees? Are you, since you're not on probation, are you paying all that today, or how are you going to pay that?
I have a payment plan.
Okay, and you understand what happens if you don't honor the payment plan?
Yes, sir.
And what happens?
Yep.
So, I'm sorry, say that again.
Come back to jail.
You come back to jail for failure to pay. So as soon as you're released, I'm going to order you to report to the Van Zandt County Courthouse and meet with the district clerk's office and make arrangements to discharge what you owe. All right, Ms. Cooper, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted.
Thank you, sir.
You're welcome. Who's next?
Judge, this is Miss Mullins.
Court calls cause number CR 21-300, State of Texas versus Julie Ann Mullins. Ms. Mullins, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hand. All right, give me just one moment, Ms. Mullins. Let me look through your paperwork here. All right, Ms. Mullins, it appears that you were before the court on July 5th of 2022. And you pled guilty to the offense of possession of a controlled substance of penalty group 1 between 1 grams and 4 grams of third-degree felony. The court heard the evidence of the case that day and your plea agreement, and the court followed the plea agreement. The court assessed your punishment at 10 years confinement in prison and a $3,000 fine. But the court also suspended that sentence and placed you on community supervision for a period of 5 years. It was during that period of community supervision that the state filed its motion to revoke your community supervision in December of 2022. Have you had enough time to review that motion with your attorney, Mr. Manning?
Yes, sir.
Are you pleased with Mr. Manning and the work he's done as your attorney?
Yes, sir.
Do you understand everything that you've read and signed today that's part of your plea agreement?
Yes, sir.
Mr. Manning, do you believe that Ms. Mullins is competent to enter into an agreement? And if so, have you explained to her her rights regarding this case?
Judge, she is competent and she did understand the rights that she is waiving in order to go forward with a plea on this case.
Does she waive the formal reading of the state's motion to revoke?
She does, Judge.
And does she intend to plead true to all counts?
That is correct.
All right, Ms. Mullins, then I would ask you at this time, how do you plead to counts 1, 2, 3, 4, 5, 6, and 7 that's contained in that motion? Are those allegations true or not true?
True.
And are you telling me that all of those allegations are true because in fact they are true? You're not just saying it to get a plea agreement?
Yes, sir.
Okay. And Ms. Mullins, has anyone threatened, force, or pressured you to plead true to any of these allegations today?
No.
All right, then the court will accept the defendant's plea of true to each count as alleged. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection as offered.
All right, that is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Judge, the one question that Ms. Mullins had is she wanted to confirm that the credit time on her stay here was correct. I told her that the DA's office had calculated 160 days, and that did line up with what she believed her credit to be.
And so that's the agreement is 160 days?
That is correct, Judge.
Okay. And I see that upon the plea of true, Ms. Mullins, that your agreement is that your community supervision would be revoked. Sentence would be assessed at 5 years confinement in the Texas Department of Criminal Justice, and you'd be ordered to pay the balance of your financial obligations, that's your fine, court costs, and those things previously ordered, and you would receive 160 days credit toward your sentence. Correct?
Yes, sir.
Okay. All right, the court having found the allegations, having accepted the allegations, the plea to the allegations is true, court finds that the defendant has violated the terms and conditions of her community supervision. Court will follow the plea agreement today. Court hereby revokes the community supervision of the defendant, assesses her sentence at 5 years confinement in the Texas Department of Criminal Justice, orders her to pay the balance of her financial obligations, and the court awards her 160 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Mullins, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Once you're released from prison, if you've not paid off all of your fines and court costs and those things, then you need to report to the courthouse to take care of it. Otherwise, your name is going to be on a list of people to get warrants, okay?
Yes, sir. Thank you.
All right, have a good day. Who'd you like next, Mr. Meany?
Judge ready, Mr. Robertson.
Court call CR 22-77, State of Texas versus Brandon Eugene Robertson. Mr. Robertson, sir, if you'll raise your right hand. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hand. Mr. Robertson, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition?
Yes, sir.
And are you currently on medication or treatment for that mental condition?
No, sir.
Do you feel like your mental condition is in any way preventing you from understanding what's going on in court here today?
No, sir.
You feel like you're of clear mind?
Yes, sir.
And are you pleased with your attorney, Mr. Manning, and the work that he's done for you?
Yes, sir.
Do you have any questions about the paperwork that you've read and signed?
No, sir.
Mr. Manning, do you believe Mr. Robertson to be competent today? And if so, have you explained to him his rights regarding the case?
Judge, I do believe he is competent. I have explained his rights, and I believe his waiver of those rights is intentionally, knowingly, and voluntarily.
All right, Mr. Robertson, you are charged by information, I believe. Is that correct? Is this a waiver of indictment?
Judge, I believe it was indicted.
The judgment says charging instrument was information.
And Judge, now that you mention it, I do remember catching that when we were signing the plea, and I apologize. I forgot to reach out to the DA's office to correct that.
Okay. All right. So, Mr. Robertson, go ahead and I'll tell you what. Let's go ahead and go over the plea, but we're going to have to fix the paperwork. Let's go ahead and go over the plea, and then y'all can re-sign later, Mr. Manning. And then once it's submitted, then we can go ahead and process it. But I think that's the only issue. Is that correct? That it's by.
Yeah, Judge, actually, I don't think we need to re-sign as long as we just can provide a corrected copy of the judgment. I can show that to my client and we can have that filed. Oh, I'm sorry. You don't accept this. Okay, I understand now. I apologize.
Yeah, it'll be all one packet. So he'll just need to go over, he'll need to see it and then just sign it digitally again. So, but we're going to go ahead and go over the plea at this time. All right, Mr. Robertson, you are charged by indictment with a state jail felony offense of theft of property greater than $2,500, less than $30,000. And that does carry a range of punishment of not less than 6 months in prison or more than 2 years in prison and a fine up to $10,000. I see the plea agreement in your case is upon your plea of guilty, the state's recommending that your punishment be assessed at 18 months confinement in the state jail prison with restitution to be determined, I guess, at a later hearing. In addition to that, you would have court costs of $290 and reimbursement fees of $85. Mr. Robertson, is that your understanding of the plea agreement?
Yes, sir. With time further.
And how much credit time does he have towards this?
Judge, he has 504 days credit time.
Okay. And so, Mr. Robertson, you would receive 504 days credit towards that sentence for the time that you spent in jail on this cause. So, understanding those things, Mr. Robertson, how do you plead to theft of property greater than $2,500 but less than $30,000?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
All right, the stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that there is a restitution request. Obviously, since this case is set on arraignment, we haven't had a lot of time to communicate with the victim to get that together, which is where that agreement to a restitution hearing at a later date came into play. The state would ask that be set on the May contested docket, just so that there's enough time for victim to get any paperwork together, for us to review it, get it to Mr. Manning for him to review, so that we can all be prepared for that hearing.
And Judge, I don't anticipate we'll have any contested issues on that. I just know that a good portion of the property was recovered. And so we just want to make sure it was limited to the property that was not recovered or that any damages that were done.
Okay. All right, anything further?
Nothing further from the state, Your Honor.
All right, court's going to review the evidence. All right, court, having reviewed the evidence, finds enough evidence to convict the defendant of this offense. The court will follow the plea agreement. Court hereby convicts Brandon Eugene Robertson of theft of property greater than $2,500, less than $30,000, a state jail felony. Court assesses his punishment at 18 months confinement in state jail prison. Court also orders him to pay court costs of $290 and reimbursement fees of $85. Court finds that the restitution amount is undetermined at this time, and the court will set this for a restitution hearing on May 29th. And Mr. Robertson should be out of jail at that time. Is that correct?
Judge, no, Mr. Robertson has holds elsewhere, so he will not be being released from custody at this time.
Okay. The court awards Mr. Robertson 504 days credit towards his sentence for the time that he has spent in jail on this cause. So I guess we need to be paying attention to where Mr. Robertson goes so that if we need to have that restitution hearing, we'll know where he's at.
Yes, Judge.
In case he's taken to other places. So, Mr. Hartwell, if you can have Ms. Abney correct the judgment to reflect indictment as a charging instrument and send that to Mr. Manning so he and his client can sign that, then we'll be adjourned in this case. But
Yes,
you
sir.
can go ahead and step over to be fingerprinted, Mr. Robertson. We're gonna take your fingerprint, and then Mr. Manning will have you sign the new paperwork. All right, Mr. Manning, who else is ready?
Judge, ready on Mr. Marcus Turner.
Marcus Darnell Turner, cause number CR 21-343. All right, Mr. Turner is in custody on a motion to revoke. Go ahead.
Yes, Judge. I'd just like to point out to the court, first of all, that Mr. Turner stands here today on his own two legs. Last time he was here, he was in serious pain and had the inability to use his legs or walk. So we're glad to have him here, standing up straight. We'd like to get this case resolved. I got some information from him today that I think will lead to a resolution. If we can reset him on the next contested docket, if I get a resolution sooner than that, I'll petition the court for him to be set on that date.
Okay, court sets Mr. Turner then for hearing on the motion to vote April 29th at 1:30. And as you said, Mr. Manning, if you get some kind of resolution before then, I do have other dates earlier. Just let me know if we can get it moved up.
Thank you, Judge.
All right, who's next?
Next, ready on Mr. DeSella James.
This is cause number CR 24-236, State of Texas versus DeSella James. I believe this motion to revoke as well.
Yes, Judge, this was my first opportunity to speak with Mr. James after his arrest. On the motion to revoke, I have some new information to provide the state. So I make the same announcement I did with Mr. Turner, a request to be set on the April 29th setting. But if I get a resolution sooner than that, I will petition the court for his setting on that.
All right, court will set Mr. James in for an additional hearing on the motion to revoke April 29th at 1:30. Who would you like next?
Next, Judge, we're ready on Mr. Zion Johnson.
Zion Dwayne Johnson, cause number CR 25-46. We're set for arraignment.
Judge, I've had an opportunity to go over the indictment with my client. His name is spelled correctly. He understands the charge against him as well as the range of punishment. He's pleaded not guilty at this time and requests to be set on the pretrial docket.
All right, the court finding that Mr. Johnson has waived the formal requirements of arraignment, court enters his plea of not guilty into the record. and the court sets this matter for pretrial hearing. Do you want that May date or do you need more time, Mr. Manning?
Judge, if we have the May 15th date, I think that should be sufficient.
Okay, court sets Mr. Johnson then for pretrial May 15th at 1:30. Should he make bail, then his hearing will be same day at 9 a.m.
Yes, Judge.
Who's next?
Judge, next reading on Mr. Henry Johnson.
Henry Daniel Johnson, cause number CR 25-44, CR 25-45. I believe we're set for arraignment in each cause. Go ahead.
Yes, Judge. Mr. Johnson's name is spelled correctly. He understands the charge against him as well as the range of punishment, pleads not guilty, and requests to be set on the pretrial docket. Judge, I would ask for a little bit longer on this one as there are some evidentiary issues that are at this time yet unsettled.
All right, the court finding that Mr. Johnson, having waived the formal requirements of arraignment, enters his plea of not guilty into the record on each cause, and the court will set Mr. Johnson for pretrial hearing. Let me make sure you're not out. How about June 12th? So that Richard has a vacation letter in. I don't see your vacation reflected on my little cheat sheet here, but let's make sure that you're not out that week as well.
Yes, Judge. Judge, I will be present on June 12th.
Okay. All right, court sets Mr. Johnson then for pretrial in each case on that day. Which like this?
Judge, at this point in time, I believe I have resolved all my cases except for Mr. Danforth. We were getting some corrections done on the paperwork, and so I don't know where we are at this point.
And I'm just working on those now. Those should be in your email, Mr. Manning, here in the next 5 minutes.
Perfect. So Judge, with that, I'm able to take a quick break to get Mr. Danforth's paperwork signed up and then corrected paperwork on Mr. Robertson.
Excellent. All right, court will stand in recess. Just notify me when you're ready to go.
Thank you, Judge.
You're welcome.
Yes, honestly, for that.
Sorry, Mr. Mayor.
Hold on just one second.
Your Honor.
Everybody up, Mr. Danforth?
Yes, Judge.
All right, court calls, cause number CR 24-303, CR 24-304, State of Texas versus Christopher Wade Danforth. Mr. Danforth, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, yes, sir.
All right, you can lower your hand. Mr. Danforth, are you a United States citizen who reads, writes, and speaks English?
I am.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
I am.
Do you understand everything that you've read and signed as part of your plea agreement?
Yes, sir.
Do you have any questions about anything before we go further?
No, sir.
All right, Mr. Danforth, I see that you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. State jail felony does carry a range of punishment of not less than 6 months in prison up to a maximum of 2 years in prison, and does carry a possible fine not to exceed $10,000. I see that the plea agreement in your case, upon your plea of guilty, the DA's office is recommending that the court convict you of this offense, assess your punishment at 12 months confinement in state jail, along with a $1,500 fine, $180 restitution, court costs of $290, and reimbursement fees of $20. Also, as part of the agreement, the DA's office is agreeing to dismiss cause number CR 24-304, which is assault of a pregnant person. Is that your understanding of the plea agreement?
Yes, sir.
Mr. Manning, how many credit days or credit time is Mr. Danforth entitled to?
Judge, the agreed amount was 184 days.
184.
That's correct, Judge.
All right. So, Mr. Danforth, you would receive that credit towards your sentence. All right. So, understanding those things, Mr. Danforth, how do you plead to possession of a controlled substance in penalty group 1, less than 1 gram?
Plead guilty, sir.
Are you pleading guilty because you are in fact guilty of this offense?
Yes, sir.
Mr. Manning, do you believe Mr. Danforth to be competent today to enter into the agreement?
Judge, he is competent and he is entering into the plea intentionally, knowingly, and voluntarily.
And you have explained to him his rights regarding this case.
I have, Judge.
All right, the court having accepted Mr. Danforth's plea of guilty, Mr. Manning, any objection to the stipulation of evidence?
Objection as offered.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, nothing in the possession of a controlled substance case. As far as the assault case, Your Honor, state is in compliance. Miss Cheney attempted to reach out to the victim. The victim said that she had the wrong number. Miss Cheney again reached out, called, ended up being the same number, confirmed that it was in fact the victim, which to me indicates that she is uncooperative in this case. Additionally, Your Honor, I've been made aware that there is expected to be some text message evidence that would indicate that the assault actually did not occur the way that it was originally reported, if it occurred in any way, shape, or form at all. So I believe that the evidence would be insufficient.
Thank you, Mr. Manning. Anything further, Mr. Manning?
Rest in close, Judge.
All right, court is going to consider the evidence. Right, the court having considered the evidence finds enough evidence to convict the defendant of this offense. The court will follow the plea agreement. On this date, the court hereby convicts Christopher Wade Danforth of possession of a controlled substance in penalty group 1, less than 1 gram. Court assesses his punishment at 12 months confinement in the State Jail Division of TDC. Orders a $1,500 fine, $180 restitution, $290 in court costs, and $20 in reimbursement fees. Further, the court does dismiss, as part of the plea agreement, cause number CR 24-304, and the court awards Mr. Danforth 184 days jail time credit for time that he has spent in jail on this cause. Mr. Danforth, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Once you're released from TDC, if you've not paid all of your fines and fees, you need to report to the courthouse and make arrangements to pay that in full or on a payment plan, okay?
Yes, sir.
All right, please step over to be fingerprinted. All right, Mr. Manning, I'm going through Mr. Robertson's paperwork again. His credit time was 504 days, correct?
That is correct, Judge.
Okay. That was- All right, the court has signed Mr. Robertson's paperwork, so that's good to go. All right, Mr. Manning, do you have anybody else?
But Judge, I believe that concludes my business. May I be excused.
Yes, sir. Thank you, Mr. Manning. Appreciate your work.
Thank you, Judge.
All right, thank you, Mr. Hartwell. Appreciate your work as well. And Ms. Tabraham, thank you, as always.
We'll
Thank
see.
you, Your Honor.
All right, that concludes our afternoon docket. Court is adjourned.
Thank you, sir. Have a good one.
You as well.